The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council and to all of those watching on our Supreme Court Live channel. I will now ask Mr. Doug Shima to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, May 27, 2021 consists of one case. Appeal number 121108, Almario Chalmers versus Brittany Burrough, Sedgwick County, briefs both sides. The appellant has reserved 2 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Your Honor, if it pleases the court and the panel, Almario Chalmers appears by and through counsel Jeffrey Lowe. He's the appellant in this matter.
May it please the court, Cheryl J. Roberts appears on behalf of the appellee Brittany Burrough.
Thank you, counsel. Mr. Lowe, you may begin with your argument.
Your Honor, before I get into the argument, I'm going to provide a brief factual summary for the panel and also those listening in. This case involves a former high-income wage earner who sought modification of a substantial monthly child support order outside of Kansas after his professional career in the National Basketball Association, or NBA, ended in the fall of 2018. His name is Almario or Mario Chalmers, former of the Miami Heat and Memphis Grizzlies. Back in 2015, when Mario was residing in Florida and playing for the Miami Heat, a Florida district court ordered Mario to pay Brittany Burrough child support and other support for the care of their daughter in the total monthly sum of $10,000. That amount of child support was based upon Mario's income while he played basketball for the Miami Heat, which exceeded $4 million gross annually. Later in his career, Mario played professionally for the Memphis Grizzlies, also of the NBA, and received approximately half in income from that which he earned while playing for the Heat. But he never sought modification of that child support until his NBA career ended when his Memphis contract expired in October of 2018. Mario has not played in the NBA nor had a contract from an NBA team from and after November of 2018. Importantly, you should note Mario has previously moved out of Florida and does not reside there. Brittany and the minor child were Kansas residents at all times pertinent here too. Mario wanted to reduce his monthly child support obligation after not finding employment in the NBA, therefore receiving grossly substantially less after playing overseas or not working at all. He filed a petition to register and modify child support in Kansas under UIFSA. The long story short, due to a failure, a clerical mistake of not attaching the underlying Florida child support order to the petition, and then again to the journal entry confirming registration, is what has brought us here today. Legally speaking, and moving into the argument, we're talking about an issue that the court needs to decide resolving subject matter jurisdiction, particularly a distinguishing between subject matter jurisdiction and claim processing rules. As an introduction, the Court of Appeals failed to distinguish between subject matter jurisdiction and claim processing rules when it held that under UIFSA, the district court did not have subject matter jurisdiction and could not allow Mario to freely amend his pleadings.
Let me clarify something. The Court of Appeals found that the registration requirements are jurisdictional because the district court, without the requisite filing, lacked the authority to modify the out-of-state order. Isn't that right?
And they found it was jurisdictional.
They found it because they had no authority to modify the order without the attachment. You're calling it a clerical error or a simple error. It's a pretty significant error. But why isn't that true? They didn't have the power to modify. Why isn't that a jurisdictional question and was resolved by the Court of Appeals properly? What's your argument? What's your argument about that?
The first thing the court should take judicial notice of is KSA 23-36-602, which deals with registration. And just look at the heading to that statute, Justice Rosen. It says procedure to register order from enforcement. Now, the Court of Appeals relied on, in particular, a 2004 case out of New York. And if this panel read the dissenting opinion of Judge Atchison, he better answers your question by pointing to a 2019 case out of North Carolina, that being the Hart v. Hart case. And he says that the Court of Appeals in North Carolina recently recognized that registration under UIFSA, quote, is a procedural requirement, not a jurisdictional one, end quote. And so that, Judge, is the fundamental difference between the Court of Appeals of Kansas and also the Court of Appeals of North Carolina. And that's the decision that you have to decide today. Is it jurisdictional or is it procedural? North Carolina says in 2019, it is not jurisdictional, which brings us into the distinguishing factor of claim processing and jurisdictional. I would answer your question a different way, Judge, going back to Civil Procedure 101 and recalling some basic civil procedure rules, which are A, subject matter jurisdiction either exists or it doesn't. Parties can't convey it. Parties can't move it. It is either there or it isn't. And if you do anything without subject matter jurisdiction, Your Honor, all subsequent orders are void ab initio. In contrast to that, using Justice Atchison's own words, quote, if a court deviates from a claim processing rule, the result is a voidable order or a judgment that the disadvantaged party must challenge in a timely manner, or any potential relief based on the defect will be forfeited, end quote. And when you have courts disagreeing on whether this is a jurisdictional one, and this is an issue of first impression in Kansas, it's you, Your Honors, that need to distinguish this out and flush this out. The practical result is a real one. This isn't a case where any fraud or undue influence or any attempt to mislead the court was done. This was in the heart of e-filing taking its place in Sedgwick County. I'm not going to make excuses as to why the underlying order wasn't attached. At the end of the day, that's on myself and my office. But would it matter to the court that a paralegal attempted to attach it in the e-file world? And the way that we e-file in Sedgwick County now compared to 2018 is much different. It probably doesn't matter, but the end result is subject matter jurisdiction to modify child support always existed in Kansas. How do we know that? Neither mom, nor father, nor child resided in Florida. It is undisputed and uncontroverted, as the court has already found at the district court level, that to be true. If Mario Chalmers wanted to modify child support, in layman's terms, he had to go to Brittany's backyard to play. He had no choice. And so we operated under that registered order, which was confirmed under KSA 23-36-605. And it wasn't challenged until many months after the fact.
Mr. Lowe, may I interrupt? Let's say we're persuaded by your argument. I want to kind of explore what the real life ramifications are. So it does, the registration requirement under UIFSA doesn't bestow subject matter jurisdiction, but it is a mandatory claim processing rule that must be enforced if it's timely challenged. Would you agree with that?
I would, Your Honor. And I would point out that it was not timely challenged in that 20-day window.
Okay. Well, okay, let's where's the 20 days?
If you go to 23-605 of chapter 36, chapter 23, 36-605, that talks about the notice of registration of an order. And it states that you have 20 days to challenge the registered order.
When did she challenge it?
Many months after that. It was January or February of 2019. I believe January 15th to be exact of 2019, Justice Standridge.
Okay, and then to get to Justice Rosen's point, if the judge had subject matter jurisdiction, so you're saying she waived the challenge. How does the judge have the ability without that attachment to modify an order, assuming the judge has jurisdiction? What should have happened? How does it go if there is subject matter jurisdiction? What happens?
Well, in this instance, the petition referenced the attached order and summarized what the underlying order was. So the court was provided notice with the underlying order.
But you
And
do
no-
agree it's a mandatory claim processing rule. I mean, it has to be attached. So the rule was broken, right?
There's no ifs, ands, or buts about that. The rule was broken. It was not
And the
attached.
judge cannot rely on the pleadings to modify child support. Is that correct? Are you saying that the judge could have ruled on the motion to modify without it having been attached?
Certainly.
There, no evidentiary support, just based on notice pleadings?
It's a verified petition, Your Honor. So the petition contained the substance of the underlying order. It summarized it in the petition, and it was a verified petition.
Okay.
And that verification is required by statute.
Didn't you basically acknowledge that there was not substantial compliance with the statute?
Respectfully, Judge, I believe there was substantial compliance with the statute, or there could have been retroactive substantial compliance with the statute. However, that is not the issue we're bringing before this particular court. That was an issue we brought at the Court of Appeals level, and we're simply focused on subject matter versus jurisdiction versus claim processing for purposes of this particular panel.
You seemed also to say that the distinction here would make it the difference between being a void order and a voidable order. You seem to acknowledge that this is a voidable order, correct?
I would, Your Honor.
And do you have any authority to support your position that gets back to Justice Standridge, that you can amend pleadings to make a voidable order a proper order?
Absolutely. First of all, you can look at it under the statute. We have the statute under KSA 6215A that allows you to, and it says freely amend your petition, which would allow you to get relation back. That was denied at the district court level. It was brought up on the Court of Appeals, and it's also before you as one of the subsections of the issues that you are asked to decide today. So that would be my first statutory authority for that question, Your Honor. Secondly, in terms of the journal entry, you can amend orders under KSA 6260, which is also cited in our brief and brought before not only the district court level, the Court of Appeals, but before you as well. Thirdly, there's a quote from the dissenting opinion of Judge Atchison that I want the court to make note of. Quote, "But if the inadequate registration simply resulted in avoidable collection orders, the payor's late attack presumably would be barred by forfeiture, acquiescence, or estoppel." And he cites the matter of MA out of the Northwest Second and also Amger Second judgments. And he goes on to say, quote, "A court's failure to follow proper procedure results in an act of excess of its jurisdiction such that the judgment remains valid but voidable, and the parties may be precluded from setting it aside by waiver of estoppel." As a practical matter, Justice Atchison makes an example in his dissenting opinion that the court would want to be aware of. He gives the example of a lady who is the recipient of child support. She's from Missouri. She goes to Kansas, where the payor of child support has moved, to register that Missouri order for enforcement purposes. He gives the example that this lady forgets to attach the underlying order. He goes on and gives the example that for 4 years, the payor of support paid under that registration for enforcement purposes in Kansas. And then he goes on to say, if you buy off on and uphold the Court of Appeals decision 4 years after the fact, after he's paid that child support, he can come in and demand repayment from the recipient of child support because the underlying order was void. She would have to pay that back, find a way to pay that back, he could seek a judgment against her under the harshness of a void versus voidable order. That doesn't sit very well with Justice Atchison, and it should not sit well with this panel. That's the reality of the decision. The second practical matter relates directly to Mario Chalmers and why the court should also be interested. Imagine this. His old child support order was $10,000 when he was making millions of dollars. After his professional career in the NBA ended, it was lowered to approximately $1,000. It's actually below $1,000 as we sit here before the court today. That's a difference of $9,000. The result of dismissal, outright dismissal of the first case, was 6 months had gone by where the old order was in place. That's a principal judgment difference of $54,000 just in 6 months. What would have happened if Ms. Burrough sat back and waited 2 years to bring this to the attention of the court? That $54,000 is close to $200,000 exceeding in principal, notwithstanding interest. What if she waited 4 years or 10 years and then came in and said, surprise, you never attached the petition, the underlying order to your petition? That's why, as a matter of equity, and if you look at the history of UIFSA and the purpose of UIFSA, it's not to have this rigidness and this harshness. The purpose of UIFSA is to prevent conflicting orders. Here, there's no conflict. Nobody was ever arguing that the underlying order was from state A and not state B, or was in a different amount. It was a technical, clerical error. A big one, I will acknowledge.
Counsel, if you're looking at matters of equity, do you also look at Ms. Burroughs' equity in, I don't remember how long it was, but in failing to meet the 20-day requirement?
I absolutely would. There's a case called from the Court of Appeals, the Dia versus Oakley case. It was cited in our brief to the Court of Appeals. I was the attorney in the Dia versus Oakley case. What happened in that case, it was a UIFSA child support case. Marvin Oakley was the payor of child support from an underlying child support order from Germany. 17 years went by before that order was registered in Kansas, where he then moved after his military career ended for registration for enforcement purposes. He argued, and I believe, in our opinion, it should have been uncontroverted. He was never served with the underlying German child support order from a paternity action filed in the 90s when he was stationed over there. The problem for Mr. Oakley, before he hired counsel, is he never brought that argument. Hey, I was never served with the underlying German child support order within that 20-day requisite window. The Court of Appeals.
But what I'm saying is that when you balance the two, based on the inadvertent mistake of not filing the original petition or the original order versus you didn't meet this 20-day deadline, is the court able to balance those equities? Because it kind of sounds like the 20-day rule means, okay, that's a mandatory, what was the word that I used? It's a mandatory claim processing rule that must be enforced.
And the Court of Appeals did not do that, nor did the district court, Justice Standridge. So yeah, I think that should be taken into consideration as well. If you're going to excuse that 20-day window for Ms. Burrough that she didn't follow, then there needs to be some level of equity given to the ability. And by the way, all that we were asking to do, mind you, was to amend the petition, which we would have got relation back under the petition in the motion. And then that 6-day window could have been resolved. I think dismissal was a measure of last resort, not a measure of first resort. And we were denied the opportunity to freely amend that petition. And
Counsel, quick clarifying question on that exact point. The refusal to amend the petition was based on the district court's finding of what? Lack of jurisdiction?
yes,
Okay, so it was the district court never actually ruled on the merits of your 215A motion. Is that correct?
It's tough to say that, Judge. I would say my answer would be yes, that is a great summary, because the court repeatedly said And here it is, quote, Kansas does not have current jurisdiction to order child support modification. So,
And so if that is true, and if we conclude that the district court made an error of law, what do we do with the fact that there was a 215A, I'll call it a 215A motion to amend the pleadings?
and there was
never ruled on, that should have been ruled on and never was.
I
If
think
that's the circumstance, what should we do now?
remand it back to the court to resolve that 6-month window of child support.
That gets me to maybe in conclusion here. Where are we at? On page 14 of your petition for review, you say that petitioner was prejudiced when he had to restart the registration. And I assume that he has restarted the registration. He refiled his petition for registration in March of 2019. So what is exactly before us in terms of the monetary impact here? Right now, you have an order in place. What you initially sought to do, you've done, right?
That is correct, Justice.
And so where is it that we're at with, is it the accumulation of the child support that was initially ordered in Florida for 3 months? What is it?
We're talking about the window from November of 2018 and the next 5 months that followed. So November, December, January, February, April, and March. April, May, not June. So it's about a 5 or 6 month window, because yes, he did refile properly. We've had an evidentiary hearing. We've gone through all the bells and whistles in that regard, and he has sought and received child support modification. So the prejudice is limited to that 5 or 6 month window, Justice Rosen.
And you're very, you basically tracked Judge Atchison's dissent. Basically, he concluded different from you, that it was voidable, it was proper, it wasn't substantially complied with. You're really not much on any different grounds than if it had been found how the majority was, as I understand it.
For purposes
you would still owe those 5 months, even if it was voidable.
Yes, but we would still have the ability to seek modification. That's the key point. And in closing, the only thing that I would remind the court, and somebody asked this question, I forgot who, I believe it was you, Justice Rosen, about is there any authority for void or voidable? Justice Atchison cites the case JSA versus MH, which is an Illinois case from 2007. He states the holding from that court, quote, courts should declare orders void, especially in collateral proceedings, only when no other alternative is possible, since disastrous consequences often attend doing so. And I want you to keep that in mind when you think about the example he gives of the lady registering the child support order from Missouri and Kansas, and keep that in mind. If nobody did anything, and it was Mario Chalmers who brought the to the attention of the court, the underlying child support order not attached to the petition. It was after that was brought to the attention of the court that Ms. Burrough filed her motion to dismiss. Measure of last resort, not a measure of first resort. We never got the opportunity to amend the petition, never got the opportunity to do an order nunc pro tunc. And I bring this case not only because it's the law, but for every legal assistant or paralegal that has had to go through this and has made a human error and a mistake. It's not only for them, but it's also the right thing to do. This isn't the law we want to create in precedent. We want to create the law similar to North Carolina from 2019.
Any other questions? Thank you, Mr. Lowe. Ms. Roberts?
Yes, thank you, Your Honor. When I initially entered my appearance on behalf of Ms. Burrough, it was around January or February of 2019. after an order had been entered without any documents attached to the original petition for registration. And I must disagree with Mr. Lowe when he said it was them that brought it first to the attention of the court. Then I filed my motion. I remember it was on a Saturday night. I don't have my email up, that I notified Mr. Lowe that I didn't know what to do with this case because there were no orders attached. Then I filed my motion to set aside. The original motion that I filed was we were alleging lack of jurisdiction because Florida had jurisdiction, and we were alleging that Mr. Chalmers still was a resident of Florida, and also subject matter jurisdiction because by failure to attach the requisite orders to the petition, the child support orders remained under the continuing jurisdiction of Florida, and there was basically nothing but a shell. You had a petition that my client was served that didn't have any orders attached, which brings up the issue of voidness. In addition, because she was never served with a proper petition that contained the attached requisite order and a certified copy of an order. I think the ruling of the Court of Appeals is sound, and it is correct because when Mr. Lowe's office filed that petition, there were no orders and no orders to be ruled on, and the court wouldn't have had any idea what to rule on because they wouldn't even know what the Florida child support orders contained. So therefore, I think that the argument that this is some clerical error, it's not just a mere clerical error that can be corrected by 6260. It is a total and major omission of the cause of action that he was trying to establish in requesting that the court here in Sedgwick County modify the Florida child support orders.
Ms.
So
Roberts?
Mr. Roberts?
Yes.
Oh, please,
ahead.
Justice Paul, go ahead.
Oh, I was going to add, and the reason why that's significant isn't so much about general jurisdiction of Kansas courts, is it, as opposed to the territorial limitations imposed on each state's jurisdiction. And we're talking about altering an out-of-state court order, right?
Yes.
And so I guess the notion of general jurisdiction, I think it's more so about the territorial limits, and the way to do that is through the registration process. Is that correct? Is that a fair characterization of the Uniform Act?
Yes.
Until Kansas
had registered orders, those orders were still under the jurisdiction of Florida.
Okay, and then just taking Justice Wall's question one step further. So would you agree that the court did have general subject matter jurisdiction, but would not be able to rule on the motion to modify until the mandatory claim processing rule?
Well, we were arguing against subject matter. Well, we were arguing against jurisdiction in Kansas, period, because our position, which was not ruled upon by the court, they didn't choose to rule on that issue, is that Mr. Chalmers was not a resident of Kansas, or he was still a resident of Florida. Therefore, it was not proper for him to be trying to register the Florida child support orders in Kansas, and that Florida had continuing exclusive jurisdiction. That wasn't ruled upon. But I do agree that the Kansas court has the ability to rule on these types of cases under UIFSA if the orders are properly registered, which they never were, thus resulting, in my opinion, and I think I agree with the Court of Appeals, and there being no jurisdiction even under subject matter as far as the child support orders were concerned, because there was nothing before the court here in Kansas due to omission of those orders.
But from what Justice Wall was saying, there's territorial limits versus jurisdiction. So do you see a distinction between the two?
I don't think they had jurisdiction because Florida had continuing exclusive jurisdiction until the orders were properly registered here. They weren't even attached and couldn't be attached. So I don't know if I'm getting the concept or semantics here crossed, but in my opinion, which is why I filed the motion to dismiss for lack of jurisdiction and lack of subject matter jurisdiction, is that you can't have subject matter jurisdiction under USA unless you follow the statute and correctly get the orders registered by attaching them.
And then what would you say to, it looks like a comment that accompanies the model you have set, which is identical to our statute, says that specifically indicates that registration is not a prerequisite to subject matter jurisdiction.
Well, that's the model rule.
Yes.
That's what it says. That's what it says. But my
Well, it's
position-
not the rule, it's a comment to the rule.
or a comment. Okay.
Yeah.
I obviously disagreed with that because to me, there was nothing here for the court to hear. So once I reviewed the petition in this case, and I couldn't even file anything or respond to anything because there were no orders. So I don't know whether the order that was issued even correctly summarized what the Florida court order stated. And my client, I would say that her due process rights were violated by her not ever being served a proper petition with the attached order so that she would know how to proceed.
Are there other questions?
Yes, Chief. If we conclude that the registration requirements are not jurisdictional, do you lose? What happens? What's your position if
I think I still win whether
yeah, go ahead. I'm sorry. Yeah, go ahead.
whether the orders are void or voidable. I think I still win because they still would have had to start all over again, filing the proper petition with the orders attached, then serving my client with the proper petition that included the orders to be registered. So we would be starting all over again at square one, whether it's void or voidable. So I think I win in either case.
Counsel, what do you think, or what do you make of your opposing counsel's argument that Mr. Chalmers should have been permitted to amend his pleadings under 215A, and if that had happened, there would be a relation back?
I don't think that's correct because you would then skip over the fact that you did not serve the appropriate pleading upon my client, which it would be in violation of due process, which would make the order void, subsequent order void as well. I don't think this is a problem that can be corrected by a non-pro-tunc because it's not a minor clerical error. It is a total omission and so major and material that you would have to start over, whether you do an amended petition or a petition, and there would be no relation back because you never did it properly in the first place and served the proper document. So the time would start. Go ahead.
Would this be an argument you would need to make to the trial court if we found that it was not jurisdictional? Is this something we would send back and you would address this particular issue?
On the relation back?
Yeah.
Well, we didn't make that argument previously, so yes, it would have to be something that would be argued. But I think Mr. Loeb did raise the argument that he should be able to amend the pleading and that it should relate back. But I don't think this is an instance where you can do that because you don't have proper service. You're asking for a benefit of saying that this is now corrected, and then you skip over the fact that my client wasn't served with a proper petition with the requisite orders, and then say that whatever order was entered because she didn't object in 20 days should stand. So I don't think it would be appropriate to apply a 60 or a relation back or allow it to be amended pursuant to any non-pro-tunc or anything of that nature. You would have to, in my opinion, file a brand new pleading and have her served with it, and then wait the 20 days to see if she objected or not.
Counsel, do you have any further argument or wish to summarize your position?
Basically, failure to attach the requisite documents as required by statute, and as the Court of Appeals stated that the court cannot exercise any jurisdiction over the Florida child support orders if and until they were properly registered in Kansas. Therefore, I'd ask that the petition of the appellant be denied and that the ruling be affirmed.
Thank you, Ms. Roberts. Mr. Lowe, you reserve 2 minutes. Mr. Lowe, you are still muted.
Forgive me. I want to address first Justice Wall's question of territorial jurisdiction that he asked of Ms. Roberts. Justice Wall, as you know, district courts, generally speaking, are those of general jurisdiction. So they have jurisdiction over matters unless that court is specifically deprived of subject matter jurisdiction over the type of the case. And this is addressing your question regarding territorial jurisdiction. This is just that subtype of a child support case where we have subject matter jurisdiction. And in terms of registration, the UFSA requirements are procedural first, and their conditions precedent, not a conveying mechanism, not a shifting mechanism of subject matter jurisdiction. And I think we all agree you can't convey subject matter jurisdiction as a matter of law. And that's the distinguishing aspect that I would ask the panel to remember. Number two, Justice Wall, please look at KSA 23-36-611. And also the comment to UFSA under 602 that says registration is a prerequisite and not jurisdictional. But when you look at 36-611, that's the modification of child support statute under UFSA. And it is clear to everyone, and it's not controverted, and the court has made this finding at the district court level, Court of Appeals and the Supreme Court, that when Florida loses the mother, the father, and the child, Florida loses continuing jurisdiction. It's up to another state to assert that or assume that jurisdiction. And it loses that. And it says so under the statute. And the court should also make a note that the district court did find, contrary to the representation of Ms. Roberts, that Mario Chalmers was not a resident of Florida. And it was stipulated by both parties that mother and child resided in Kansas. So the court should make
Counsel,
note.
does that have more to do with due process limitations over the court's personal jurisdiction over the parties, as opposed to the territorial limitations of subject matter jurisdiction?
No, that is subject matter jurisdiction. Who can modify child support? And it's you got to go to the non-moving parties state to modify. So if Ms. Burrough wanted to modify child support herself, she wouldn't go to Kansas for that unless Mario Chalmers was a resident of the state of Kansas. So it is absolutely 100% subject matter jurisdictional based. The final point that I want to bring is regarding Justice DeGaule's question, Your Honor, regarding KSA 6215A and the relation back. We cited and Ms. Roberts stating something along the lines that she didn't understand or appreciate the possibility of relation back and amending the petition. In our Court of Appellate brief, we cited to the record Ms. Roberts' acknowledgement to the court of her early on request to amend the petition. Ms. Roberts represented to both myself and to the court that Mr. Chalmers needed to amend his petition. So how to do that, the statutory authority for that is KSA 6215A. And under subsection C of 215, you get relation back. If that happened, we have a pending petition, we have a pending motion, and the merits of that motion, whether or not modification from $10,000 to something else would occur, meaning Mr. Chalmers would at least have his day in court. The problem here is he never had his day in court for those 5 or 6 months periods. And that's all we're asking for. The court may very well determine no modification to be proper, but we never had the opportunity to make that argument.
The 20-day rule that notice rule that you talk about requires that the foreign order is registered. Uses that language. Was it ever registered in Kansas when the 20-day rule would have been in effect? Does that even come into play?
That I would argue, Judge, that's a difference without distinction. And the reason I say that,
Why? I mean, it is registered.
we had an order
never
confirming
registered.
registration would be my answer to that, meaning there was a court order that confirmed registration of the underlying order.
From Florida, you mean?
No, from Kansas. So
Even though the court was never in possession of it.
correct. Meaning there was mistakes not only on the registration level, but even the order confirming the registered order had that same mistake as well, Your Honor, in full candor. And so, yes, we did have an order confirming registration, and it was months after the fact that this clerical mistake was brought to the attention of the court. And for those months that followed, that Kansas modification order was followed, and enforcement of the Florida order was not sought at that time.
Any other questions? Thank you to both counsel. The court will take this appeal under advisement. The court is now in recess.